Oh, hello everybody. I hope you are well. This is Cynthia Gallardo. I'm so excited to be here with you. Just if you could let me know in the chat or in the question if you can hear me. I want to make sure we are all on the same page and can hear each other as we go through this. And once again, thank you so much. I know you'll do love what we're discussing today about preserving and protecting your legacy. Well, first protecting and then preserving your legacy. So we're definitely going to go through some really interesting information here for you. So we'll go to get started here in about 1 minute. I just wanted to come on and officially say thank you for joining us. I'm so excited to be here with you. Thank you. All right, we will officially get started. And once again, my name is Cynthia Gallardo, with Legacy Law Boutique or Cynthia Gallardo Law LLC. And as you can see, I'm your leading legacy lawyer. I am so excited to be here. And I do want to just do a few housekeeping rules. First of all, today is about you. That's why I'm here. I want to make sure I'm able to share information that's really important for you to be able to take back and utilize to protect and preserve your legacy. So as you can see in the picture there, I have a picture of my husband, which is we're part of the same legacy, right? And a picture of my 5-year-old son, who he just turned 6 yesterday, son Elijah, and he's definitely a handful and definitely part of my legacy. So, and when we think of legacy, we think about lessons learned, but also material assets, and it's lessons learned throughout your life experience that you want to share now in the present, what you've taken from the past, share it now in the present, and then of course leave a footprint, a positive imprint in this community, the world, and going forward. So that's what legacy is about, and that's why I'm so passionate about it, because I want to help others be able to do the same thing. So as we talk through this, I want to make sure you know that, I appreciate you, first of all, taking the time to be here with me personally today. And we'll be talking about 45 minutes, 30 to 45 minutes today. And I'll be able to share with you what no one has told you about estate planning. That's right, what no one has told you about estate planning, because estate planning can be overwhelming. And I've taken it, a great friend of mine always used to say, well, Cynthia, how do you eat an elephant? And I would always say, well, I would never eat an elephant. If I did, it would be one bite at a time. And that's what we're doing today. Taking estate planning one bite at a time, or one step at a time. That's critical and important. And also, as part of the housekeeping, I want you to know, if you do have questions, go ahead and go into the questions or the chat section. I have that available to me to be able to see. And I can definitely address anything real time for you as well. Okay. Oh, thank you, Brittany. I appreciate that you can hear me. Yay! Thank you. And it may have been earlier when I thought I was in mute, but yes, my husband was leaving the house, part of my legacy, right? So thank you for sharing that with me. Appreciate it. All right. So if we come to today's discussion, I say class, but it's really more of a discussion, right? This is like a personal legal consultation for you, and we'll discuss what a will versus a trust, and which one is right for you and your family. And also, you'll get a special gift for attending today's session, and then also open it up for questions and answers. So I do want to make this as interactive as possible. So if you do have a question, please let me know as we go through this. So I want you to know that you are in the right place if you know you need an estate plan, but you aren't sure where to get started. That happens to many people, so no worries. You are curious how long the process will take and what's involved. You are definitely in the right place. And also, I'm going to double check here real quick here. You are wondering why you can't just do your own estate plan. And I'm going to be very authentic with you. A lot of times people know that they can go do their own estate plan. You can go on to, different forms and documents. But I will say, and I know, Brittany, you know this, Louisiana, we're very special, right? In the sense that very unique here, and very loving. The community is amazing. But the law here is very specific to Louisiana. We are the only ones to carry on the Napoleon law, or the civil law. Every other state uses common law. So you want to be very careful and utilize the right formats, the right details involved with the law to make sure it is a valid will and or a trust. So that's one of the key pieces that I would like you to take away from that. So I want to share with you here just a little bit more about myself, Cynthia Gallardo. I'm an attorney, a lawyer, author, speaker, coach, business strategist. I love helping individuals protect and preserve their legacy when it comes to either to an entrepreneur, a family, or what I call legacypreneur, because we all create legacies and we all have that entrepreneurial spirit to really expand and help others be the best version of themselves. And if you'll notice in my logo, I have a DNA. I love DNA because it really helps us understand who we are, and then we can value ourselves first and and help others value themselves as well and value other individuals. So that's a key part of why I do what I do as well. And then also I have my information there if you want to write that down, Cynthia at cynthiagallardolaw.com, and my phone number for you as well. And just a few things about me. I'm a member of the Louisiana State Bar. I am barred in Louisiana. That's the only state at this point that I'm barred. I'm a member of the Wealth Council, what we call, and it's a great community of individuals to be able to answer those type of questions, maybe nuanced questions that we have about estate planning. So I tell you that because I am surrounded by individuals that it's a great resource, a great community. So if I don't know the answer, I can definitely find it for you. And then also I'm a member of the American Bar Association, the Lafayette Bar Association, and I'm a graduate of the National Entrepreneurs Association, and I'm a member of the American Immigration Lawyers Association as well. So some common objections, just to transition into, well, I don't think I need a will or a trust right now. So some common objections are, my spouse will take over, so what does it matter? I'm too young to need a will. I don't have enough money to need it. So those are just some of the objections. And I always tell people this: you're never too young to need a will. And then as far as money, there's always opportunities or options available to you to be proactive and protect and preserve your legacy. And when people say they're too young, I always share this story about a cousin of mine, a personal experience. It was definitely a tragedy, and it still affects me a lot to this day. But I'm one of 32 grandchildren in our family, and I'm excited to say that out of the 32, we all very close. We stay in contact with each other. The only thing is, we did lose one of my cousins when she was 30 years old, and she had 3 children at the time. She was an entrepreneur. She had 2 different spas at the time in Illinois, and it was a tragedy because no one expected it. She was I guess fishtailed by a 18-wheeler. She pretty much died instantly in the accident, and I can tell you she did not have a will or a trust in place, and it definitely caused a lot more pain than it could have been prevented with a will or trust. So I always tell people, you're never too young. Always plan ahead. And then I bring up the story about I have 3 nephews in the military, and they're going in, very young, and they have to complete a will before they go into the military. So if they're doing it that young, we can do it as well. We should be doing it at whatever age that we need to do to protect our legacy, right? Everybody has a legacy. I just want to reinforce that. So people always ask, what's the risk to your family if you don't have a plan? That's a great question, and there are many risks. So I'll share a few of those risks with you. First, I want to share with you that the goals of estate planning. So the risk is, if you don't plan, somebody will plan for you, and it will be the state. And I'll go through some of that information with you as well. Now, if you do plan, then this is what happens. You're able to give what you want and what you have to those that you love, those that you want to give the part of your legacy to, or carry on your legacy. You can care for yourself during your lifetime. There's living wills that we can prepare as well, such as during times of incapacity, health, and financial power of attorneys as well. That would be all bundled in together, just so you know. You can also care for and protect others, such as your spouse, your children, and then also making sure that you protect yourself, because the decisions you make today will affect you in the future, will affect your children, affect your family. And I'll talk about that a bit further. Fulfill your charitable donations or intentions. You pass on, and this is the one I love, passing on your values and ideals to children and grandchildren. I always think of my grandparents. I lost all 4 of them. I don't have at a young age. I wish I would have had time to really spend with them and write things down, their lessons learned, all their experiences. And that's something I really do. And I'm proud to say that I really encourage individuals to write down their lessons learned, video it, and have it available for your loved ones, when something does happen. So you're preparing for the expected and the unexpected. And then also maximizing your assets, distributed to your loved ones. You minimize taxes due at your death, and you protect your assets from creditors, divorce, bankruptcy for generations to come. And it was fun, my sister were talking, reading, we saw a little TikTok video, right? And it says trust babies are only for rich people. That's not true. You can have a trust baby with anything you have, as long as you have a asset to put into your to a trust. You can have a trust baby, your trust family, your trust legacy, and I'll discuss that a little bit more with you as well. So once again, if you have any questions as we go along, you can go into the questions section and ask anything you may have, and I'd be more than happy to assist you with that. So just a little bit about the goals, once again, about estate planning. Definitely goals that you can achieve, and it's by having a structure or a plan, a strategy, just like with anything in life. So then we talk about documents of estate planning. People always have questions about this, right? What do I need? What type of documents are valid here in Louisiana? Well, I'll tell you, a last will and testament or a revocable living trust is what we'll talk about today. Power of attorney, which I do bundle into the will and or the trust, whichever is decided upon. Advanced healthcare directive. What we call final disposition instructions. Nomination of guardians for children. Optional separate trust for children, and this is what I'm very big on, because you can create a separate trust for your children that will protect them. It's like a protection within a protection. So I always think of those little, if you think of those little weeble wobble eggs, or they go one inside of the other, well, that's what we do. We create a master trust, a family trust, so in this case, a Gallardo family trust, but then I would have a children's trust for my son Elijah to protect him in the future as well. And then also irrevocable trust for estates valued more than $5 to $6 million. There's a special law regarding that can be put into place. So do you have an estate plan? It's a rhetorical question, but not really. I want you to really think about that. Do I have an estate plan? You might think you do, but I can guarantee that if you think you do, you probably don't. So if it's not written down, it's not documented, if it's not, I would say, reviewed by somebody that has experience in that field, then most likely it's not something that would be valid, but we can discuss that further as well. And then also, it's just that the state has written it for you. So if you think you don't, you do, and the state has written it for you. So that's what we call intestate probate, when an individual does not have a will. So estate planning is opting out of the state's default plan for your family and assets. So basically what you're doing by creating an estate plan, a trust, and or a will is that you're letting the state know, the state of Louisiana know, that you are taking the responsibility or utilizing your right to basically create your plan for your family, for your legacy. And that's really a big responsibility we have. It's an important one, and I can tell you it's definitely something that you want to take advantage of and not allow others to make the decision for you. So doing nothing means you get the default plan. And what's that default plan? I go back to intestate law or intestate probate for individuals in Louisiana. So when that happens, I can guarantee you most likely the assets will not go to the individuals that you want them to go to. So I always tell people, put yourself in the driver's seat and create your plan proactively. So the default plan, we'll talk a little bit more about that here. What does that mean if you allow the state to create the plan for you and you have what's called that intestate probate? Assets are distributed according to the state law, and it would go to people you don't want, possibly don't want to, right? Kids get, or your children, your legacy, get inheritance at the age of 18 years old, and it's outright. And one of the things I always say, at 18 years old, most children are not mature enough or responsible enough to manage a large amount of money. So if you get it in a lump sum, it can be lost easily. And also it could be lost in a divorce, or it could be spent unwisely, which I'll share a little scenario with you in the near future here. Also, the spouse could remarry and cause asset distribution to someone other than your kids. And I get that question a lot. So with this trust, you'd be able to create it where something happened to one of the spouses and they get remarried, the asset distribution would be based on what you specifically had laid out. And that has to be documented very clearly, and that's something that I could help with. And then also the judge will decide who raises your minor children if you don't have it laid out specifically who the guardians will be. And then the judge will decide who is in control of your children's money. And then, of course, you go to probate court, and that's more costly. It takes more time. You just have to consider, the pros and cons to each option that you give or have. So you think about, what about your minor children? So I know Brittany's on the call. I know you have that legacy. You have children. I know I have children, and we always put children at the forefront, right? What can I do to protect my kids, my children? Well, who will take care of your kids if something happens to you? You can name legal guardians in a last will and testament. And if you pass away without a will, a judge will decide who gets custody of your children, what we call permanent guardianship proceedings. So I always tell people, let's say hypothetically you did not have somebody listed as a guardian. Well, what happens normally in that case? It takes time to get to a judge. They may assign a temporary guardian, but think of all the time, the weeks, the months that go by before that your children would be placed permanently with somebody. So it's basically taking the steps to make sure from day one your child is protected and a guardian is named. And then also a temporary guardian if that particular guardian lives out of state or out of the country. So a permanent guardianship proceeding is rigorous, complex, lengthy, and expensive. And I know I personally would not want my child, my son Elijah, to have to sit through something like that, and just having all this change occurring around him where I could have prevented that. My husband and I could have prevented that from happening. So once again, it's being proactive and keeping your legacy, which your children are part of that, at the forefront. So a lot of times family members battle each other for custody, leaving courts to make the final decision. And of course, nobody wants to see their children this way, right? Where they're just so overwhelmed and stressed out. So if we lay everything out, are proactive with it, it makes a big difference. So I appreciate you understanding that. And I know you value the feelings and what your children go to, the experiences as well. So have a plan to protect your children. You can name guardians in a will or trust, that's a part of it. But also, I take it a step further with individuals. List your backups and say what happens if your guardians get divorced or one passes away. So always have a backup plan, right? Plan A, plan B, and plan C. You want to make sure you have that peace of mind that your children will be with those that you know will protect them just as much as you would as well. So you have the choice. You're in the driver's seat to choose those guardians. So for guardians outside Louisiana or outside the U.S., your nominated guardian can live anywhere in the world, but there are things to consider. And as I mentioned before, you have to consider the time it would take that individual to get to your children to be able to care for them. So you can nominate temporary guardians in lieu of or until that individual, the permanent guardian, would come and be able to take responsibility of the child. And then also, of course, with anything with guardians, it's of utmost importance to put your wishes in writing. And then a judge will make the decision, and you want their job to be as easy as possible. And that's why putting it in writing, it's always easy, right? Or easier, I should say, not always, but it is much easier. So then we get to the question once again, well, what about the money, right? We talked about part of your legacy, that your children, what about your assets? And that's a great question. So what is an estate? A lot of people have that question. It includes checking accounts, saving accounts, car, boat, motorcycles, brokerage accounts, stocks, bonds, life insurance proceeds, houses, other real estate, your retirement IRA, 401k. It could be any type of additional assets, coin collections, jewelry, artwork. And also one that people don't consider, and I also work with individuals regarding this, intellectual property. So what about that name of your business, the logo? What about your tagline, slogan that comes in as part of your intellectual property and adds a value to your estate, to your assets? And then also your business interests such as the LLC, etc. So all these things encompass your estate. So it's not just one thing or two things, it's many things. So I always tell people, most of us have at least one of these things on this list. So you have an estate, and that's something that you want to proactively protect and preserve. So I put this slide here because I love ice cream. I love options. So what are your options? Here are your two options. And I make it easy because you really technically only have two, right? You can have a last will and testament, or you can have a revocable living trust if you want to be the one in the driver's seat and take action. Now, if you want to use a default plan, that's option 3. Allow the state to basically force you to go through probate, or your loved one, family and loved ones to go through probate. But I know that's definitely not our case. We want to be proactive and we want to plan ahead to protect and preserve our legacy. So let's talk a little bit about a last will and testament first. I always like to give the pros and cons of each, and then of course each family will make a decision about their legacy and what's important and the best option for you and your family. So a last will and testament, it's truly better than nothing. I can guarantee you that. I shared with you some of the experiences, like with my cousin having nothing. It just makes life so much harder for those that are left behind. And then name guardians for your children, of course, and then of course the grandchildren of your parents or your in-laws. You want to make sure that you are naming those guardians so it's an easy transition, an easy handoff, to be able to protect and preserve your children. And then name beneficiaries for assets owned by you individually. So I'll talk a little bit more about that as well. You always want to make sure that it's very specific about where you want your assets to go. And we'd lay that out very specifically in your last will and testament. And then you name an executor to wrap up your affairs, or it can be assigned to, by the court. But if you name it, it's a lot simpler and easier as well. So let's talk a little bit about the cons, right? Where does a will fail? And this, I always tell people this. If you're okay with your information being public, then that's fine. You can check that one off or mark it off, because a will is public. The entire case goes public once you go through probate. So anyone would be able to know what your children inherited, what your spouse inherited, what your loved ones inherited, your beneficiaries. So if you want to keep that within your family, then definitely a will is not the way to go. It's not applicable to incapacitation. So I want to make sure people know that once you want to be able to have that bundle package I shared with you, to be able to be prepared in all aspects regarding incapacitation. And then you cannot cross state lines. Also inheritance at age 18, age 18. And remember I said one lump sum for an 18-year-old can be very tempting. So we want to make sure we protect our own legacy in that aspect. And then no flexibility for giving instructions. You can have some instructions, but I can assure you, based on my experience, a trust is more specific as far as what additional detail that you want to add in. And you'll see some of the benefit when we go through that here, through the trust momentarily. So I always say this: where there's a will, there's a probate process, right? So if you have a will, it's going to court. There's no way to get around that, and it will become public knowledge or information. And it takes time as well. So in Louisiana, we actually call it succession. So a lot of people say probate, it's a succession where it goes from one individual to the other, right? The individual, the intestate, I call her the testator, the person who created the will, and it's handed off to their loved ones, their beneficiaries. So it can be expensive, time consuming, and it's also public. The public knows what's out there and who is given what assets. So probate can be expensive as well. So it can be 2 to 7% of the estate assets can be lost in the probate process. So I'm just going to share a little bit about that with you, just to give you an example about Rebecca, right? So if Rebecca has real estate worth $800,000, a savings account $50,000, brokerage account $200,000, and then life insurance payable to the minor as a beneficiary of $2 million. And it could even, take that down to $1 million. But in this case, for the example, $2 million, 401k payable to the minor, $1,700,000. So let's say hypothetically, this one would be a $4,750,000 probate, estate probate. So if you take that at just the lowest amount of estate tax at 1%, you're going to come up to $4,750,000 times the 0.01, and it comes out to $47,500 lost in probate. Now, I know me personally, if I had that amount to work with, I would definitely want my loved ones to be able to use that amount versus losing it in a court system. So that's just something to think about long term regarding your particular estate. And that's something that we'll talk about, because there's certain steps that are followed in order to determine what's best for you and your family, and you can make the best decision. Then you come to Sam's probate estate. So Sam has a real estate of 300,000, savings account, etc. So that if you break that down, his total probate estate would be $1,150,000, and if you take it at 1%, he would lose $11,000 and $11,500 to probate or the succession process. At 3%, $34,500. So once again, I go back to what I would think personally is I wouldn't want to lose any money. I'd want to be able to give anything that I had, pass it on to my loved ones, right? My legacy, to my son Elijah, to my spouse, or my sisters, whomever I decide as a beneficiary at that time. So it's really important. It puts you once again in that driver's seat to be able to determine where your money goes and the amount of money that goes to them as well. So I love this slide because you can see here throwing money to burn. I know me personally, I have no money to burn. I don't know about any here, but I'm always looking to help people protect that money, right? Instead of putting it into a fire, you're going to put it into your bag for your legacy, for your loved ones. So just a few other points I like to bring out about a downside of probate. It's complex, very complex. Families typically need to hire an attorney and get a judge's approval on everything. And it can be very, very exhausting mentally and emotionally. Most people, and physically, most people don't want to have to go through that. Once you know they've lost their loved one, they might want it to be as easy as possible for their loved ones. Probate can be a long process, and it can take several months, even up to a few years. And I don't know if you've seen this, but there are many high level celebrities, right, that their wills will take years and years, even decades, to be able to determine where the assets go and what beneficiaries receive what. So it's definitely a process. I just want to make sure you understand that it's a manageable process, yet it is a process that's complex, but it can be maneuvered. So when is a will-based plan appropriate? And I like to break it out this way. In Louisiana, we have the option of what's called a small succession. If your estate is less than 125,000 in Louisiana, you can actually do what's a small succession. It's just a very simple document. It could be notarized and taken and recorded with the court. So that's very, very simple, right? And then also, of course, if there's going to be some type of concern regarding what's in the will, there might be some anticipated litigation as well. So if that's the case, then you probably do want to go the will-based route at that point. And also, like I said, it just depends what's right for you and your family at the particular circumstances, at any particular circumstances. So I always tell people in law school, we used to talk about what's called the totality of the circumstances. So you have to look at the big picture. Everybody's unique. Every situation is unique. And that's where a strategy plan would come into play to determine what's specific need, the specific need for your family. So for many, and I say many because it's not everybody, there's those in that specific situation that I mentioned earlier, but for many, the better option is a revocable living trust. So when I say revocable, it can be changed within your lifetime without a problem. And we'll cover a little bit more about that. So a revocable living trust can cover everything a will would cover and more. So it would substitute the will. It would do this instead of a will. So very similar to a will, but a little more protection. Name beneficiaries for your assets in the trust. And the trust is revocable. You can change or amend it at any time. And you are the trustee during your life. You have total control. So it's basically, for example, in the Gallardo family trust, I'm in control of that trust as the what we call a settler or a grantor. I put the assets in. I'm also the trustee. I control it, and I'm also the beneficiary. Now I can utilize the fruits of that trust. And then in the future, if I'm not around, of course, the beneficiary would become my spouse and my son. So there's different ways you can work that, but there's 3 key elements of the trust that I'll go through in just a moment. And also, the revocable living trust avoids probate if it's properly funded. And that's very simple. Basically, you have to, everything you own is taken from your name. So for example, it'd be taken from Cynthia Gallardo or Dennis Gallardo, and it'd be put into the Gallardo family trust. So it's taken from us and it's put into the trust. And then also, it's, as mentioned here, everything you own now is outside of your trust, but then you would have to move it into your trust. That's called funding. your trust, and you retitle the information. So our car would be Gallardo Family Trust. Our home would be under Gallardo Family Trust as well. But keep in mind, I'm still in the driver's seat, my husband and I, because we are the trustees. We control what's in that trust. And the benefit of this is everything in your trust bypasses probate when you pass away. So in this case, if something happened to my husband and I, Elijah would be the beneficiary, and then everything would just pass over to the person that we designate as a trustee to oversee that, with my son Elijah as beneficiary until he's old enough to be able to take control of the trust himself. And then you still maintain control over your assets in the trust, as I mentioned, and that's critical. People knowing, I want you to know that you are still in the driver's seat. You're in control. So then you can plan for and protect your children with a revocable living trust, as I mentioned. It's far more flexible than a basic will. Your ability to nominate one relative as a guardian, but someone else to incrementally disperse money for proper care of your children. I love that. It's like a checks and balance, right? You have the guardian, and then you can have a second, even a third person in there being able to identify, to work and make sure that the money is being used or dispersed in the best benefit of your children, of your legacy. And then financial care for your children will happen based on your instructions in a way that protects those funds from creditors and predators. And I really like that, because a lot of times when people become aware that somebody has inherited money, remember, with the probate, they're going to know right off the bat. With the trust, they can still find some information, but it's protecting them. Anyone coming to try to get something that may have been in your name, they can't do it, because it's not in your name here. It's under the family trust, and your child is protected. And then money meant for your children's care will not be tied up until court will authenticate a will, or as part of that succession plan. So they immediately are able to utilize the funds. So I think of that when I go back, and I think of it like a relay race, right? You pass the baton in a race. There's much energy put into that, and much practice, and that's the same thing with a trust. You pass the baton on, and you don't drop it, you don't lose it, you don't lose any time. It's just you keep going, right, to win that race. And so you aren't trusts only for rich people. That's the question I had posed earlier, and I can tell you they're not. Anybody who has assets, you can create a trust to protect your children and your legacy, and basically carry on that positive energy, that synergy that you have into future generations, or that generational wealth. So what is a trust? Basically, a trust is an agreement that you spell out the rules you want followed for the assets owned by the trust when you pass away. Very simple, 4 simple things. So it's an agreement, it's a contract. You're spelling out exactly what you want to happen when something happens to you, right? Planning for the expected and the unexpected. And then your assets go to those that you want them to go to. So putting this another way, a trust is all the things people assume are done by a will, and you have it documented in detail. So I always tell people, I want you to feel comfortable knowing that exactly what you want is going to happen, and that's explained in the trust document. So I'm going to give you an example of Dan. Dan has one asset, which is a $100,000 bank account. He wants to leave it to his son Jimmy when he dies, but he doesn't want Jimmy to get the money until he's 25 and has graduated from college. That's a pretty good age, right? 25, a little bit more than 18, so he can mature a little and know what he needs to do and wants to do with it. So Dan definitely needs a trust, because you'll need to create that secondary children's trust that I mentioned. Remember, putting these kinds of conditions into a will have no legal effect. It's a trust where they become effective. Basically, you can't put these kind of conditions into a will. You cannot say, when my son turns 25, then he can do this. In a will, it's automatically at the age of 18. So it's a one lump sum for that individual. Like I said, 18 years old, $100,000. Well, it may be been spent. So we have to be careful with that. So as I mentioned before, there's 3 roles in every trust, 3 key elements. And I know me, I'm a visual person. So when we went through this in law school, and we had to practice and practice, I created a triangle. And on the top peak of my triangle, I put the word settler, because in Louisiana it's called a settler. But I put the word grantor here because it makes more sense, right? You grant, or you fulfill, you put your assets into the trust. So you can put grantor or settler on the top peak of that triangle, and that's the person who contributes the assets. So in this case, my husband and I, to the Gallardo Family Trust. Then on the second individual or role would be the trustee. And usually what I would do is put that on the bottom prong of the triangle on the left hand side. You put trustee, and you could put your name, your spouse's name there. So in my case, my husband and I would go there. And these are the individuals who manage the trust assets. And then on that triangle on the right hand side, that right peak or that right prong, you would put beneficiary. And this is basically the beneficiaries are those individuals that are entitled to the assets. So in that case, I would put our son Elijah, and he would be the beneficiary in this case. So remember, I talked about you can put out plan A, B, and C. So I could put my beneficiary if something happens to me. Before something happens to my husband, then he becomes the beneficiary, and then also the beneficiary would be Elijah if something happens to my husband first, and so forth. So keep it in mind, you would place yourself as a beneficiary as well to basically be able to benefit from the fruits throughout this process. So the gift of total control is an awesome thing. It gives you that peace of mind, right? So I introduce you to Henry and Wanda. Henry and Wanda occupy all three positions. As I mentioned, you can have more than one position within your trust. That gives you more control. So you have the grantor or the settlers, which would be here, Henry and Wanda. The beneficiaries, which they put themselves as the beneficiaries as well, and the trustees, where they have control of what goes into the trust. And so they take all the roles, and you could do the same within your trust to be able to protect yourself now and then of course into the future. So the three roles in every trust allows you to be in control, completely 100% in control. It can be amended or revoked at any time. So hypothetically, if Henry and Wanda sell the home, or the trust sells the home, they can make the changes that they need to. If they purchase another home, they can put the title into their family trust versus their individual names. And once again, that adds protection to the assets that they have. I love to think of it this way, and I know you definitely, Brittany, will be able to understand this concept, right, with these little backpacks, right? So a revocable living trust is like a kid's backpack. I think of my son's backpack and all the things that go into it. That's basically, those are the assets that go into your trust. And I apologize, let me go back one screen. So this little backpack there, that is what your trust, it's an analogy, right, or a description of what your trust would be. And it avoids probate for all things inside the backpack. So remember the probate process I talked about earlier? Anything outside of this backpack would go through probate, but anything inside of it, you pass on like that baton in a race, you pass on immediately to the next person. Well, I say immediately, there is a small process, but nowhere near the probate process, I can assure you of that. So a trust solves all problems that come with a will. Or I would say concerns, right? That's a little better word. You won't lose the 2 to 7% of your estate in probate court or the succession process. Assets go to your loved ones in weeks and not years, and totally private during your lifetime, and also at death. Totally private process through this, which is what I like for my son. I don't want people knowing out there knowing what he has or does not have. So it gives me peace of mind personally. So living trust and guardians. With the living trust, your family will get access to your money much sooner than a will. Designated guardians will take custody of the minor children, and that'll be pretty much immediately unless it's, like I said, anyone outside of Louisiana. That may take longer to get here, or outside of the country, but there are processes in place for that, where you put that temporary guardian until the permanent guardian comes into play or is available. You may want the nominated guardian to have access to money as soon as possible as a resource, and you can do that with a trust, which is pretty cool. You can allow them access immediately to your funds, so that your legacy, your children are never without wanting of something, right? There'll always be access to them and for them. So things parents worry about that possibly could happen after they're gone, right? I know I worry about different things. Well, what if this asset or this lesson learned doesn't reach my child, or they're not able to benefit from it? So parents worry of this about their children, that their adult children get divorced and family assets go to strangers. And that has happened, and it does happen. So you want to protect that from happening. And then also that their adult children lose their inheritance to creditors or lawsuits. And that can happen. I'm actually going to share an example with you here in a few moments where, an inheritance, something happens out of the ordinary, that unexpected event, and well, your child will lose everything you've worked your entire life to save for them to a creditor. So we want to prevent that from happening. So is each child ready for a huge lump of distribution at cash, excuse me, at the age of 18? Absolutely not, right? And in fact, there's Financial Planning magazine stated clients' biggest concern for their wealth after they're gone is that someone will take financial advantage of their children or grandchildren. And like I said, it does happen more often than we think. So protection, that's key. So I'd like to introduce you to Denise and Sam. So I know when I was in law school, we used to create like those DNA and me, or those family charts, like remember like family trees. So we created family trees when we went through different scenarios of situations. So if you'd like to create, if you're taking notes, create a family tree. We have David and Sarah as the parents, and then they have two children together, Denise and Sam. So Denise and Sam are the children, and the parents are David and Sarah. So Denise's husband is Richard. So you can put Richard next to Denise, and they meet, they get married, and they decide, well, we're going to have, we're going to get married and enjoy our life together. So the inheritance funds are often commingled with jointly held funds. So let's say that Denise inherits funds, and if they get divorced, though, Richard would get half of those. Normally inherited funds are protected, but if you commingle, they become part of that community property, and then the spouse will get half of those funds. So what can you do to protect yourself? Well, that comes into play with the trust. If you had that children's trust in play, it would not become part of those funds. You would not be commingling them. So that's just a protection for your daughter. Well, we'll say the daughter Denise, right, in this case. Then you come to Sam, the son of David and Sarah. He's very accident prone. And one day he accidentally left the water running in the bathtub and went out for the night. And what happened? He lived in a town in like a apartment complex, and the downstairs neighbors sued Sam because he left the water running, and all kinds of damage, mold started to grow, etc. And Sam lost his entire inheritance settling the claim, the money that had come to him from David and Sarah, because it was not protected. So this unexpected event caused Sam to lose all his inheritance. And why? Because it was not protected, right, in a trust. So I like this analogy. We think back to toothpaste, right? I know there's always that long-running question, which is better to roll the tube, how do you trickle the toothpaste out of the tube, right? And I know you can either roll it up, or there's different ways of doing it, but ultimately, a distinct trust for your children can operate like a tube of toothpaste, right? Little by little, you can trickle it out. So, and you can protect it as it's pouring out. So you safeguard your inheritance in your plan. A trust for your children can hold their inheritance. So like in the case of Denise and Sam, it would have protected them. It's like a tube of toothpaste. You can squeeze it out when your children need it, but it remains in the tube, and it's protected from divorces, lawsuits, creditors, and bankruptcy. And you can also designate the trustees, and this can even be your adult child, as I mentioned earlier, and that would be laid out specifically based on age that you choose, etc. So they can be the beneficiary and the trustee at a certain point. And your plan can put protections in place as well. So you can let them know per year you want such and such amount, and if you can incorporate different prices increasing through the years. So there's different things you can do to protect and and let those assets come out little by little for your children. So how does it work? The revocable living trust avoids probate. And then trust for your children, it protects your children's inheritance from lawsuits, bankruptcy, and divorce, like in the examples that I shared with you earlier. So what about the taxes due at death? So right now, these are 2022 numbers. It's very similar for 2023. And I'm definitely not an expert when it comes to taxes, but from a general perspective, I'd like to share this information. Estates greater than these amounts are subject to federal estate tax at death. So for an individual, it'd be $12,060,000, and for a couple, it'd be $24,120,000. So if you fall under that category or the amount, then you would not have estate taxes at death. You would have other taxes, of course, but not the estate taxes. And rules are different if you and or your spouse are non-citizens, which I know is not the case here. So, just some things to think about. So, how big is your estate? Your gross estate, and I focus on the word gross because your gross estate includes life insurance, proceeds paid at your death. Also, laws change all the time. In fact, in law school, we'd always say that the law is fluid, it's ever changing, and that is so true in all aspects of the law. You could have a taxable estate in the future, even if you don't have one today. And you can avoid or minimize taxes due with the help of an estate planning attorney. So that's where I would come in, be able to help you protect what you have, your legacy, and really identify the best way to save you money in the long run, which we've shared a few already based on probate versus the trust. So what are your next steps? Great question, great question. I can guarantee you knowledge is not enough. You need an action plan. So what do you need to do? How can you make it happen? When should you get started? And what's the investment to get it done right? Those are all very important questions, and I pose them to you so that you can go back, think about them, meditate on them, because I always tell people plan for the expected and the unexpected. We want to make sure that we know, we're here to protect and preserve our legacy. I go back and I reinforce the example of my cousin who passed away, and I also always share the example of someone we know in the community that the mother was struggling, right, financially struggling. Her son was actually a police in the Houston area. He was in an accident on the job, and unfortunately he died instantly. It was very much a tragedy and unexpected event. And fortunately for the mother, in this never getting back her son, of course, and that's the biggest thing. But the son took steps to protect his legacy, his mother. He had no family in this case. He protected his mom, named his mom as a beneficiary of his insurance, and she was able to benefit from that, right? In the sense that she's now able to live I would say a better life financially, even though her son's not here, and she said she would give the money back in a moment, right, to have her son back, which is of course the case. But I tell that story because that one decision her son made to protect his mother goes a long way, and that's what we're doing today. We make decisions to protect our legacy, our children, our spouses, those that we love. So that's why it's important to answer these questions and do it quickly as well, right? We can't keep putting off what we know we need to do. So very important, making sure you find the right attorney, one you feel comfortable with. You want to always think about is what's the main focus of the attorney? Do they work well with others, such as insurance, tax, financial advisors? Does the attorney charge a flat fee, or do you know specifically what you're getting? And does the attorney have a process to keep your plan up to date? And then also, can I see myself working closely with this attorney? So all great questions, and I encourage anybody that I come in contact with to be able to think about those things. And of course, I would love to work with individuals, but I also want to do what's best for you and your family. So there's 6 simple steps, and fortunately, you can actually click off one of those, right? I'm a big list a person who writes down lists, and I love checking things off that I've completed them. So the first one you can check off because you're attending the class today. The second one would be. The second one would be peace of mind legacy planning session, and that basically gives you peace of mind specific to your needs, your family's needs. Then you would have a strategic design session where that's where we actually go through. You would see. I would actually work with you, get all the details for your will and or your trust, and then we'd have a review session, and we could do that in person or via Zoom, and then also a signing ceremony, and that would be in person, and then a complimentary annual plan review. So 6 simple steps. Fortunately, like I said, you can check off one, and then I'll talk to you a little bit more about the legacy planning session here in just a moment. So who the peace of mind legacy planning session is for? So who is it for, right? People who have watched or the online class or recently recorded webinar, or the one that you're going through now, so that you can make the best decision for you and your family. And people who do not have an estate plan or believe that their plan is outdated. And then people who are ready to get started with the process, right? And also, you must be a resident of Louisiana for me to be able to help you, since I only practice law, estate planning law in Louisiana. So what about money, right? What's the cost? Well, I ask you this, right? Rhetorical question. What's the cost of failing to plan? So just think about that. And I would only recommend something if it'll save you money in the long run. And I think you can see just from the information that I've shared with you today, you will save money in the long run if you go with the trust versus the will. But like I said, it's specific to the needs of your family that we'd be able to identify what is best for you. I'm big on a pros and cons list. I made many decisions that way, so I always encourage those that I work with to do the same. So the most popular packages I work with are revocable living trust and what we call a pour over will. And I would be able to discuss that in further detail with you. Also the children's trust, the power of attorneys, the advanced healthcare directive, and then what we call a HIPAA waiver, because I've also seen that happen so many times. If you don't have the right documents in place, it's almost impossible for your loved ones to get the information that they need. You know, it's a protection by law, of course, because it protects individuals, but sometimes we need to get around that and utilize the information that may not be at our fingertips, and this will prevent that from happening. So that would be packaged all together, 1 through 5, and then you have the living will option, which would be the living will, the nomination of your guardians, final disposition instructions, portfolio binder, and electronic copies of the documents. So in all of these, I do give a portfolio binder and then also the electronic copies of the documents. And I love the part about the final disposition instructions, because I personally am very big on you writing down the key lessons learned that you want to pass on to your children, and even doing a short video. There's so many, I mean, I wish I would have had more videos with my cousin or my grandparents that passed away. And that's something I want to make sure we carry on as part of your legacy as well. So we talked about lanyap earlier. What's that free gift, right? Well, I do want to share with you, I am offering that lanyap, a little bit extra here, that free gift. So if you recall from the 6 steps, the first one is attending a webinar, whether it be in person like you, through the webinar platform, or a recorded webinar. So you can check that one, check that slot off. The second one option was, of course, or the second step was to attend what we call a peace of mind legacy planning session, and that's where it's specific to your needs. A lot of the information I covered today is very general, so we dig deeper into your particular needs at this point. And normally that would be $525 for that session, but of course at this point, because you're attending the session, today's session, I would offer it to you at no charge. I'm not saying free because it has value, but you would get that credit, so you wouldn't have to pay anything. And if you book a session with me within the next 72 hours, the session does not have to be within the next 72 hours, but I would like you to book it within the next 72 hours, and then you would be able to receive that discount, okay? And then we would talk about packages at that point and what's included with each of those. So your next step is book your legacy planning session within the next 72 hours, and you'll be able to get that discount, that savings that I mentioned, that lanyap that's out there, and be able to look at your specific needs and find out what's best for you and your family and how to protect and preserve your legacy. So I did go over about 5 minutes, so I do want to be sensitive to that. I want you to enjoy your afternoon here, but I do want to open it up if you want to put into the questions or the chat. If there's anything you'd like me to cover, if you had any questions regarding anything, I can definitely assist in any way possible. So I'm here to help and to make sure you feel comfortable with any decisions you make to plan for the expected and the unexpected. And I always say that, right? Expected, we know things happen. We know that we're going to reach a certain point where something will happen with us, but the unexpected is like the situation with my cousin and or the individual that I mentioned that was a police officer in Houston. All right, so I think we're done with that. I really appreciate it once again, you joining this afternoon to talk about something that a lot of people sometimes fear, right? But I always say be proactive about things, making sure that the plan is laid out. You can have that peace of mind, and let me tell you, peace of mind goes a long way, and it's very invaluable, truly invaluable. So any other questions out there from anyone? Oh, I see a question, Brittany. So yeah, you can. Oh, very good question. Is there email handouts that you could send me regarding the next steps and what you offer? So yeah, definitely. Great question. I really appreciate that, Brittany. So what I can do, I can follow up in an email. If you could, you have my number there. Just send me a quick text and let me know, with your name and that you're just a reminder to send you out the follow-up email, and I can definitely do that for you, and I can lay out the next steps for you so you can discuss that. And just so you know, because you did attend today, so if we do the Peace of Mind Legacy Planning session, that would be at no charge to you, and I would go over the basics with your husband as well, be in there, because it is important that both of you are there, and then we go through the detail of your specific legacy at that point too. But I'll give you an overview for, to share with your husband, okay? I hope that helps. Oh, yes, no problem. My pleasure. Thank you. Yes, thank you so much, Brittany. I appreciate you joining, and please tell Geraldine I said hello as well. I appreciate her, making that connection with us and for us. So thank you. So if you do have any other questions that you can think of, Brittany, feel free to text me as well. I'm definitely open to sharing anything I can to make your decision easier. Okay. Thank you. I appreciate you taking the step to protect and preserve your legacy. So with that being said, I'll go ahead and log off and close it out. Oh, good. Yes, she will be excited. Thank you, Brittany. All right. Well, you have a great day. Take care. Enjoy your fantastic Friday. All right. Bye.